Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, listen, we've already done a couple of videos because we told you that the lawsuits were going to start flying on ATF's new rule on firearms with attached stabilizing braces, what we're calling here the pistol brace rule. We did this video right here. We talked about the very first lawsuit. Then we got to follow it up with this video right here, which talked about the second lawsuit. But you know what? There is a third lawsuit, and this one has some really, really unique plaintiffs that I think makes this really worth talking about. So today, let's spend a few minutes and talk about when more than half the states sue the ATF over the pistol brace rule. Okay, so the case we are talking about today is Firearms Regulatory and Accountability Coalition v. Garland, a case filed in the Western Division of the District of North Dakota. Okay, there are many named plaintiffs in this suit, many named plaintiffs, including SB Tactical and B&T USA. But what makes this lawsuit really unique, and you are going to love this, is that there is 26 states, that's right, a majority of states in the United States that are suing the ATF. Now, leading the charge is West Virginia Attorney General Patrick Morrisey. So kudos to AG Morrisey, who has led the charge. He has garnered 25 other states to join him as plaintiffs against the Department of Justice, Merrick Garland, the ATF, the federal government. The states that are participating as plaintiffs in this lawsuit include West Virginia, North Dakota, Alabama, Alaska, Arkansas, Florida, Georgia, Idaho, Indiana, Iowa, Kansas, Kentucky, Louisiana, Mississippi, Missouri, Montana, Nebraska, New Hampshire, Oklahoma, South Carolina, South Dakota, Tennessee, Utah, Virginia, and Wyoming. And for the hometown crowd here in Washington State, yeah, you will see that Washington State, shockingly, did not join the party, nor did the state of California or the state of Oregon, but I digress. So let's get to the pleadings, which were drafted by the West Virginia Attorney General's office, and as expected, they are really good. Now, as we start tracking these various lawsuits that are dropping on the pistol brace rule, we're beginning to see that there are some common threads, that is, similar arguments that are being made in every single one of these, and for good reason. And then we're seeing that plaintiffs are taking different tacks depending on how they see the legal issues. And I've always said that this pistol brace rule is a cat that can be skinned many, many ways. Let me get you through what plaintiffs are saying in this case, because they've done a really nice job of drafting the pleadings. I want you to understand where they're coming from. The arguments that they are making, in no particular order, are as follows. Number one, that the rulemaking itself, that the rule itself is unlawful. In fact, the rule is not needed because we are clarifying terms that don't need any clarification. As plaintiffs put it, in ATF's single-minded quest to treat pistols modified with stabilizing braces as subject to the National Firearms Act, it failed to heed the statutory text by which it is bound. The NFA and GCA statutory definitions do not reach pistols equipped with stabilizing braces. The statutes covered weapons manufactured as short-barreled rifles and weapons made from rifles. Contrary to the rule, the statute does not cover guns manufactured as weapons other than short-barreled rifles or short-barreled guns made from weapons other than rifles. And what, of course, the ATF is saying is, listen, there's all of these terms like designed to be fired from the shoulder and intended, and what we needed to do was further define that. And plaintiffs correctly point out that no, you don't, for the following reasons. ATF misapprehends the term designed as used in 26 U.S.C. section 5845. The rule considers irrelevant evidence that the stabilizing brace makes firing a standard pistol more accurate or more enjoyable. Thus, ATF cannot read the term design to exclude all evidence showing that a stabilizing brace is suitable for use as a brace. Now, the other thing, and we are seeing this common argument, especially in the second lawsuit that we talked about on this video right here, which is, hey, listen, now ATF is saying, hey, the definition of rifle apparently is vague, and so we need to further define it. Well, that also means that the statute might be subject to more interpretation than one. And unlike when we're talking about civil administrative actions and we get into all the crap that comes with the Chevron deference, now when we're talking about putting people behind bars, when we're talking about putting people in prison and labeling them as felons and seizing property, now actually the rule of lenity applies. And the rule of lenity suggests that if a statute is subject to two reasonable interpretations, it is the interpretation that is advanced by the defendant that the court will adopt. As plaintiffs' counsel put it, at the very least, the NFA is grievously ambiguous as applied to pistols equipped with stabilizing braces, as evidenced by ATF reading the statute to not cover these weapons for more than a decade. Under these circumstances, the rule of lenity requires excluding brace-affixed weapons from the scope of the NFA. And then in addition to those arguments, we're seeing some of the more traditional Second Amendment arguments under Bruin and Heller and things like that. Now, this is an argument that was also identified in the second suit that we did, and I think this argument is brilliant, okay? Because when we take a look at what type of historical tradition we have as regulating types of firearms, and this is not new. This doesn't come from Bruin. This comes all the way from the Heller opinion, okay? Is that under the common use test, we have established that there is a tradition of allowing regulation of firearms which are dangerous and unusual. Not dangerous or unusual, dangerous and unusual. And so what the federal government is now arguing is, well, these guns are particularly dangerous and unusual, and therefore we need to be able to have the authority to regulate them. The problem is that their own math works against their argument. This is how the plaintiffs put it. ATF's rule also construes the statute in a way that would raise grave constitutional doubts under the Second Amendment. With millions of stabilizing braces in circulation, even by ATF's conservative estimate, braced weapons are plainly in common use and thus protected by the Second Amendment. Additional arguments. How about this? And this is very true. The rule is so poorly written, shocker, that it is completely unworkable. That is, we start from a standard that nobody can understand, and then we apply further standards to it that nobody could understand. This is how plaintiffs' counsel put it. The rule is also hopelessly unworkable. For example, the rule says that ATF will first assess whether a brace provides surface area that allows the weapon to be fired from the shoulder. But that inquiry raises an obvious question. How much surface area allows the weapon to be fired from the shoulder? ATF, without giving a reason, declines to specify a quantifiable metric for what constitutes surface area that allows for shouldering of the weapon, and will not attempt to precisely measure or quantify the surface area. And of course, this comes down to one of the most simple tenets of all laws, which is that all laws need to be understandable and need to place identifiable boundaries on our behavior. And when we are using subjective terms to define what goes from legal to illegal activity, laws fail to put citizens on notice. And when laws fail to put citizens on notice as to what their expected behavior is, then there is a significant constitutional deficiency with that law. And of course, there's the whole problem with one of these criteria upon criteria that we're using now is how we subjectively interpret marketing material. That too raises serious constitutional concerns, and this is how plaintiffs' counsel put it. ATF also advises parties that it will look at marketing and promotional materials as well as informative demonstrating the likely use of the weapon in the general community. But ATF does not commit itself to any kind of standard for how it will weigh or assess this information. Indeed, the preamble credits some individual characterizations of a brace while writing off others as anecdotal and not even relevant. Elsewhere, it divines from generic anti-establishment marketing slogans and unstated intent, quote, to avoid NFA controls. And then to put a little cherry on top, plaintiffs' counsel also added, ATF's factors are little more than window dressing for the agency to reach its preferred outcome. Now, another argument we're seeing, and this is a new one here, and I like this one a lot, is the adjudications. And the adjudications, for those of you who really geeked out on the pistol brace rule and taken a look at the page, you know there are a lot of other documents that were attached or released at the same time as the rule. One of the things was these final determinations about certain types of firearms or adjudications, where basically the ATF has come out and said, these guns right here, these guns are illegal. You can't have these unless they are registered with us. Of course, they provided no data. Interestingly enough, they did not give us any examples of firearms that were legal, but we digress. Now, this adjudication thing, it creates a lot of constitutional deficiencies, and this is how plaintiffs' counsel put it. Along with the rule, ATF also issued dozens of adjudications purporting to classify as short-barreled rifles common firearms and weapon platforms equipped with the most popular stabilizing braces in the United States. These adjudications contain no analysis and consist solely of photographs of brace-equipped firearms or weapon platforms labeled short-barreled rifles. Like the underlying rule, adjudications are completely untethered from the statutory text they purport to apply. And to show you exactly how absurd it was, the plaintiffs very wisely took the SB Mini, a brace that many of us are very, very familiar with, and pointed out the absurdity of the flip-flopping position of the ATF as follows. The adjudications confirm that the ATF believes its rule will allow it to achieve whatever outcome it wants regardless of the facts before the agency. Take, for example, ATF's adjudication of the SB Mini. ATF has twice before issued preliminary classifications concluding that a pistol affixed with the SB Mini is not a short-barreled rifle. Now, ATF says that it is a short-barreled rifle. Okay, and then just to make sure that we got the complete panoply of all arguments that can be made, there are separate claims made under the Administrative Procedures Act. We're not going to get too far into the woods there. We did geek out on the APA on this video right here. But essentially what they're saying is two things. Number one, the rule in its application is arbitrary and capricious, which it most certainly is. And number two, the rule in its inception, in the rule making and the way it came about, was done in an ultra-virus way, or essentially outside the statutory scope of what the agency can be doing. Has the ATF ever acted outside of its statutory scope before? And this is exactly the types of issues that we're seeing. And as I mentioned, with everything that the ATF has been doing, and when we take a look at this larger and larger presence that they've been making throughout all aspects of the firearm industry, there is no doubt that they have consistently been stepping out of their lane as it relates to the separation of powers and any restrictions placed upon them by the APA. Okay, the suit once again is the Firearms Regulatory Accountability Coalition v. Garland. We will put links for the opening memorandums and complaints down below, and obviously we will keep posted about this. We will keep tracking this, as we will with all the other lawsuits related to the pistol brace rule. In the meantime, if any of you have any questions about the pistol brace rule or what's left of our Second Amendment rights, you guys know what to do. You can always contact us at WashingtonGunLaw.com, or you can call us directly at 425-765-0487. Now, in the meantime, let's remember, part of being a lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.